What is the difference between a court-appointed attorney and a retained attorney? At a very basic level, everyone is entitled to a legal defense. This means that if you cannot afford an attorney to mount a defense on your behalf, the court will assign one for you. Now, of course, the court is going to go through a process of determining whether you are truly indigent, meaning that financially you need the assistance of the government in order to have an attorney defend your case. And if so, you will be appointed an attorney. If not, you will have to retain or hire your own. The key difference here is a court-appointed attorney is not someone you choose. This isn't someone that you have researched. It's not someone that you've read their reviews or met with them and determined that you have a good or solid connection with. Because it's not someone at the end of the day you decided was best for you and your family. It's someone the court provided for you. If you don't like your court-appointed attorney, you don't get along with them, you don't like the strategy or the effort they're putting into your case, firing them is near impossible because you're not the one who hired them. The government is. That's not the same with your retained attorneys. If you retain an attorney and things are going south, which hopefully that's never the case, you hold the power to hire someone else. Now, if you have a court-appointed attorney and you decide that you want to move forward and the court won't let you fire your lawyer, you can always hire someone, but again, that requires access to finances. And the type of attorney you're probably looking for, the one with the most experience or the best communication or excellent results, can be expensive. Another big difference between court-appointed attorneys and retained attorneys is workload. Court-appointed attorneys are assigned cases as their name comes around a wheel. It really depends on where you are. Some counties have what we call public defender's offices. Public defender's offices work kind of like district attorney's offices, where they're an office of government employees that are assigned all of the public defender work in a particular county. Those can carry humongous caseloads, and in doing so are giving less and less time or less and less effort to your case individually. Other counties, like Tarrant County, for example, have a court appointment wheel. And what this means is you have private attorneys who are qualified to sit on certain cases be assigned to those case dockets. The issue there is they don't have a lot of control over how many cases they are assigned. The Texas bar says that we should remain under 200 cases at any particular point. That's just an ethical obligation in an effort to give the right amount of time and the right amount of effort and resources to any one individual case. You can bet that public defenders' offices or attorneys who accept mostly court-appointed work have a far bigger caseload than that. Private attorneys have much more control over their individual docket because they get to decide whether they will accept a case or not. A responsible attorney's office who accepts only retained work will only accept a case if they know that they have the time and the resources available to dedicate to and mount a considerable defense. That's why it's so important that part of your consultation conversation with any retained attorney is, what's your workload? Do you have time to take my case? And if you have the time, do you have the resources to contribute to a defense? This is just one of the many differences between court-appointed attorneys and retained attorneys. Well, I hope that helps. And if you have any other questions, feel free to comment below. Again, my name is Anna Summersett. I'm one of the partners here at Varghese Summersett Law Firm. Thanks for watching.